On January 12, 2017, the Utah Court of Appeals issued its decision in the case of Blocker v. Blocker. Here is the link to the full decision of the court, and we include that link in the description section of this video report. In August of 2009, following entry of the parties' divorce 5 years previously, the court granted father sole legal and physical custody of the child on father's petition for a custody modification. Although the child's therapist and the court-appointed custody evaluator recommended that mother's parent time be supervised, the court decided to permit mother unsupervised parent time, provided that she retain a special master and verify her participation in individual therapy and joint therapy with the child. Eventually, mother sought a modification of the parent time order, which was heard June 2015. The court decided to make an August 2014 temporary order, which granted mother unsupervised parent time, permanent. Father objected, asking the court how it could modify a custody award without first finding there had been a material change in circumstances. The court told father it had, quote, wide discretion in these matters, close quote, and that there was, quote, satisfactory evidence in the file to demonstrate that this decision is in the best interest of the child, close quote. It ordered that mother's unsupervised parent time be made permanent without entering any findings of fact. Father appealed, contending that the district court erred, quote, when it failed to state any finding that there had been a material change in the circumstances upon which the previous visitation award was based, close quote. He cited a two-step process when modifying parent time rights. First, the court must make a finding that there have been changes in the circumstances upon which the previous award was based that are, quote, sufficiently substantial and material to justify reopening and questioning of custody. And second, the court must determine what custody arrangement would have served the child's best interest. The Supreme Court of Utah has acknowledged that the change in circumstances required to justify a modification of a divorce decree varies with the type of modification sought. Whether there has been a material change with respect to visitation is a different inquiry from whether there has been a material change with respect to custody. While the inquiry with regard to parent time does not rise to the same level as the substantial and material showing required when a district court alters custody, it still requires a showing of a change in circumstances. Although a district court need not find a substantial and material change in circumstances to alter parent time, it is still required to find some change in circumstances. The court in this case made no findings that a change had occurred, even when father pressed the court to address this issue. The court likewise made no specific findings regarding the best interest of the child. Because there were no findings to review, the Court of Appeals could not determine whether the district court's decision was based on correct legal principles or whether it was supported by the evidence. Because the Court of Appeals was unable to conduct a meaningful review, the Court of Appeals remanded to the district court for more detailed findings of fact.